As immigration battles continue to play out in Washington over family separation, a citizenship census question, and more, Massachusetts now moves center stage. U.S. Attorney Andrew Lelling today indicted a state judge for obstruction of justice.
The grand jury has found probable cause that a judge intentionally interfered with a federal investigation by letting a fugitive out the back door of a courthouse so the feds would not get him.
It all started last April when Jose Medina Perez was arrested on drug charges, appeared in Newton District Court on an outstanding drunk driving warrant against someone with the same name. But just minutes into the proceeding, his defense attorney asked Judge Shelley Joseph if they could speak about his client. He explained that a federal agent was outside the courthouse waiting to pick up Medina Perez in a conversation that was caught on courtroom audio and recently obtained by the Globe.
What if we continue?
Larry, can you go off the record for a moment?
At that point, the court recorder was turned off for almost a minute, and later, after the hearing ended, the Globe reports Judge Joseph denied the ICE agent access to the courtroom. Medina Perez was then released from custody, let out the back door, where he reportedly scaled a fence and ran off. And now retired court officer Wesley McGregor, who allegedly assisted Joseph, was also indicted for obstruction of justice and for perjury. Last year, after Lelling called for a grand jury investigation, Governor Charlie Baker spoke out against Joseph, who he appointed in 2017.
Look, judges are not supposed to be in the business of obstructing justice. We'll wait and see what the investigation concludes, but I don't think she should be hearing criminal cases in the meantime.
She did continue hearing cases as recently as last week, but today, after the charges were announced, the state's Supreme Judicial Court issued an order suspending Joseph without pay. Joining me are Derege Demissie. Did I get him close?
Very close.
You're very kind. Thank you. He's the president of the Massachusetts Association of Criminal Defense Lawyers. Thanks for being here. Brian Kelly is a former assistant U.S. attorney in Massachusetts, now a partner in Nixon Peabody. Brian, it's good to see you, too. Thanks for being back.
Thank you.
So let's say, for argument's sake, that all the allegations factually are true. Isn't this a matter for something like, I don't know, the Judicial Conduct Commission, rather than a grand jury and a criminal indictment of this woman?
Well, no. Look, every prosecutor has discretion to decide which cases to bring. And here, if the charges are true, then in fact it's a serious crime. You have a state court judge obstructing justice, and you have her courtroom clerk lying about it in the grand jury. That is serious.
I think this is a completely political decision.
Why?
This is the same Department of Justice that just a week ago said there was no obstruction of justice on the part of the president. And if you accept everything that was said in the indictment, and I just got a chance to read it, there is absolutely no misconduct whatsoever. First of all, to obstruct justice, there has to be a pending proceeding. There was nothing pending. There was a final order of deportation, and that was just being executed based on an administrative warrant.
State court rules say neither hinder nor help federal authorities. And in this case, if the facts are true, she clearly, and her clerk clearly, hindered their efforts. Did she not?
No, absolutely not.
How would you say that?
So the judge has absolute power to control what goes on in her proceedings. There was a question of identity in this case. In fact, the defense lawyer requested to speak to the judge at sidebar, raised there was an issue of identity. Jim,
and said that he was not the person for whom he was a fugitive,
and also asked for the person to go downstairs to get his property. He left in the process of after he obtained his property.
He's clearly wrong on many levels here. Of course, it's a serious crime if the facts are true. You can't conspire to make sure an illegal alien escapes ICE when ICE is there to do its job. And if Lelling wanted to be political, he wouldn't have brought the charge. Obviously, this is a heavily liberal democratic state. He could have just announced he wasn't bringing charges, and he would have been praised by everyone in the establishment of how even-handed he is. He's actually being, in my opinion, somewhat courageous in bringing this, because he knows he's going to get lambasted by the media in this state.
This is clearly a political decision, and I'm not saying it's made on behalf of the people of Massachusetts. It was made on behalf of Donald Trump. This is a message the administration was trying to send.
If I can interrupt a second, Andrew Lelling was asked today about whether there was a political motive. Here's what the U.S. Attorney had to say.
I know this may seem counterintuitive to some. This case is not about immigration. It is about the rule of law. Over the last year, more than I would like, I have been compelled to remind the public that we don't get to pick and choose the federal laws that we follow.
I want to ask you about the second half of that, since you worked in that office and you worked alongside Lelling. I've been compelled to remind the public we don't get to pick and choose the federal laws we follow. As recently as last year, Andrew Lelling was said when he's asked about marijuana prosecute, including by me, he said, that's not my priority. My priority is opioids. You guys, when your former life, you pick and choose what federal laws to enforce all the time.
I think you're absolutely right. He's wrong on that. Of course he picks and chooses which laws to utilize. There's a giant book this thick, and I agree with you. He has failed to prosecute all these marijuana traffickers who are masquerading as cannabis growers now. But that's besides the point of this case.
Well, no, it's not, because he could have decided here not to prosecute, and as I said, let a conduct commission investigate.
Well, in every case, he could decide not to prosecute. They have so many opportunities to prosecute or not prosecute, but it has nothing to do with Trump. This has everything to do with, does this U.S. attorney in this state want to use his resources to prosecute what he thinks is a serious crime?
They picked the weakest case, and a case that should not even be in federal court, to charge a state court judge who chose to administer her courtroom in a certain way. Judges should have autonomy. This is a state
autonomy
right
to turn off the tape recorder for 52 seconds.
Do so. Absolutely,
that's not in clear violation of trial court rules.
Judges
to turn off the recorder.
Judges turn off recording all the time.
Especially one second, Brian, please.
If there is an impoundment, a judge impounds a proceeding. That tape gets turned off by the judge and then turns back on after personal information is passed on. If there's a question of identity where Social Security of a person is discussed, that has to be off record, off tape, and the judge has to, by law, turn off the tape.
But wasn't based on the surrounding facts, before the tape was turned off and after the tape was turned back on, it was clear it was for none of those purposes. It was clear that she wanted, clear to me, that she wanted no one to hear what she was discussing about possible release of that prisoner.
There was an issue of identity. When you discuss issue of identity, you're discussing date of birth, Social Security number, and all identifying information.
Is that not true when you were a U.S. attorney?
If this was an American citizen who was wanted on tax charges and there was an IRS agent in the courtroom, she wouldn't have had the American citizen go out the back door and escape. This is all because they didn't want ICE to catch somebody who'd already been deported twice,
saying that judges are discriminating against American citizens?
Well, if you look at this case, it's an aggressive prosecution. And what does that tell me? It tells me they have very strong evidence. It's not a weak case. If you look at that indictment,
a very weak case.
If you look at that indictment, it's clear to me that the defense attorney is a witness.
So let's talk about something that is the allegations here is that let's stay with the judge, forget the clerk for the moment, took affirmative actions. Let's assume there weren't affirmative actions, but there was a directive for non-cooperation. Rachel Rollins, the new Suffolk County DEA, was here a couple of weeks ago. She has been quoted repeatedly here and elsewhere saying very upset when ICE has attempted to snatch people, according to her, in courtrooms. If she issues a directive to her DAs to say, do not cooperate with ICE in any fashion, is she violating federal criminal law as well, and should she be prosecuted?
Well, I think would be a very aggressive interpretation of the statute, and I don't think it would apply. Here you have affirmative actions to make sure a defendant in the courtroom avoids apprehension by an ICE agent who the judge ordered out of the courtroom according to the indictment. Now, look, she's presumed innocent, but I think if the government wants to bring this case, they must have a strong case or they wouldn't bring it.
The whole purpose of this case is to intimidate judges. This is about intimidating judges. It's about sending a message.
Intimidating judges to do or not do what?
Break the law. Just to be intimidated not to break the law.
To not do anything in regards to protecting people. For example, ICE is interfering in court proceedings on daily basis in Massachusetts.
By their mere presence.
By their mere presence. Witnesses are refusing to come forward. Defendants are not coming
Does that not concern you, by the way?
He's just making it up.
No. By the way, police chiefs have sat here and said the exact same thing.
ICE only arrests criminal defense. They don't arrest family members or anything like that. No. There are laws in this country about whether or not
their very presence in the courtroom causes obstruction of justice in Massachusetts.
Or witnesses not. Again, police commissioners and chiefs have sat here, Brian, and said exactly
and we've called on the Attorney General of Massachusetts to bring a federal lawsuit against the U.S. Attorney's Office and ICE to stop interference in court proceedings. And state court judges have to have the autonomy to run their courtroom the way they see fit.
They
You have the
don't
last
have
15 seconds.
They don't have autonomy to violate federal law. And if, in fact, this judge, who is presumed innocent, violated federal law, she'll be treated like everybody else, and she'll have her day in court.
This is a very weak case, and I'm sure Judge Shelley will prevail.
Thank you, Brian, for being here.
Thank you very
It's good
much
to
for
see you as
having
well.
us
Gentlemen,
here.
thank you both.